Morning, everyone, and thank you. Welcome, DA Katz, to the ongoing conversation we've been having with New York City's district attorneys about the criminalization of mental health. We are so pleased that you were able to join us today. And thank you also to the Greenburger Center for partnering with John Jay to educate the public about the problems that arise when people with mental health needs come into contact with the criminal justice system. I'm looking forward to hearing from DA Katz about how her office is addressing these problems. Before we hear from DA Katz, it's worth noting that issues relating to mental health and the criminal justice system are not limited to New York City. The criminalization of mental health was raised as a nationwide issue at a series of convenings that John Jay hosted last fall in partnership with the National Organization of Black Law Enforcement Executives, NOBLE. These convenings brought together elected officials, advocates, researchers, community leaders, and criminal justice leaders from around the country to talk about the most pressing public safety challenges. The consensus that emerged from these convenings was that we need to reorient how our society addresses people with mental illness by providing treatment and services rather than a criminal justice response. The Future of Public Safety report that John Jay published with NOBLE identified a broad set of principles and strategies that communities around the country we hope will consider implementing in support of safe and healthy communities, including for those with mental illness. The report also highlighted the work that jurisdictions are doing around the country to compassionately respond to people in mental health crises. For example, Denver's Support Team Assistance Response Program sends a team that includes a mental health professional to appropriate 911 calls. Ultimately, contact with the criminal justice system should not lead to tragic consequences for people who are experiencing mental health issues. District attorneys have an important role to play, along with other government decision makers, in protecting people with mental health issues from the harms they can suffer if they are arrested, prosecuted, and jailed. Once again, I welcome DA Katz to this conversation and thank her for talking to us about how her office approaches people with mental health issues, including both victims of and people charged with crimes. Before we begin this conversation, I want to share a bit of background about DA Katz and about our moderator, Cheryl Roberts. DA Katz was elected in November 2019. DA Katz is the first woman to serve as Queens County District Attorney in the city of New York. Under uniquely challenging circumstances related to COVID-19, DA Katz has dedicated herself as district attorney to ensuring the safety of the 2.25 million plus people who live, work, and visit Queens, while implementing meaningful changes in the criminal justice system. Among her year one accomplishments are the creation of a conviction integrity unit to restore justice to the wrongfully convicted and an enhanced community partnership division to strengthen ties to the myriad communities that comprise the most diverse county in America. DA Katz has made a number of other important changes to the office since she was elected. She restructured her office with a number of new bureaus, including major economic crimes, hate crimes, human trafficking, frauds, violent criminal enterprises, housing and worker protection, and a cold case unit. She hired specialists in the fields of immigration and forensic sciences. She's launched initiatives to aggressively pursue and prosecute human traffickers, child abusers, and those who prey on the elderly. DA Katz is raising her two children, Carter and Hunter, in the same Forest Hills home where she grew up. And we're also happy to have a fantastic partner and moderator for today's event, Greenburger Center's Executive Director, Cheryl Roberts. In addition to serving as Executive Director of the Greenburger Center, Cheryl is the Corporation Counsel for the City of Hudson, New York. Previously, Roberts served as a town judge in Columbia County, New York, and served as a counsel to committees in both the U.S. House of Representatives and the U.S. Senate. I'm now going to turn this conversation over to Cheryl Roberts and DA Katz. Thank you.
Thank you, President Mason, and good morning, DA. Thank you for being here. We are looking forward to the next hour and learning more about what you are doing in Queens to decriminalize mental illness. We are also so pleased to be partnering with John Jay College of Criminal Justice on these conversations. And we are very honored that President Carol Mason provided those opening remarks. I wanted to take a moment To give some background on President Mason before we begin, Carol Mason was nominated by and served with President Barack Obama as Assistant Attorney General at the Department of Justice, where she headed DOJ's Office of Justice Programs and oversaw an annual budget of $4 billion, which supported an array of state and local criminal justice agencies, juvenile justice programs, and services for crime victims. President Mason also oversaw the National Institute of Justice and the Bureau of Justice Statistics, and led the department's work to address the issue of community trust in the justice system. In May of 2017, Carol was appointed as president of John Jay College. So thank you, President Mason, for partnering with us. It is our honor, and thank you for your introductory remarks. So now I want to turn to a conversation with DA Katz and talk a little bit about some statements you made, DA, during your campaign, where you paid special attention to people living with mental illness. You said, quote, "When a person with mental illness is accused of a crime, it demands specific protocols within the district attorney's office, working with advocates and mental health professionals to determine the appropriate course of action from a prosecutorial and/or treatment perspective," end quote. So tell us what specific protocols you have implemented in your office to help divert this population.
Well, thank you for having me. And first of all, Ms. Roberts, I want to thank you for the work that you do on behalf of Greenburger, the Greenburger Institute. And of course, Ms. Mason, I built a little bit of a relationship during my days as borough president and council member with John Jay. And we are always excited to work with both institutions. And thank you for having me here today. We have taken the idea of treating mental health illness and looking at each defendant specifically and following a protocol that we've put in place. We have increased diversion programs for people with mental health or behavioral health disorders that we identify as they come in, especially when they're accused of misdemeanor charges. Additionally, we have a mental health court for felonies and a second court for misdemeanors. And both have been in operation since fall of 2005. When I came in, though, I wanted to put a little more teeth in what they were doing and make sure that even if you don't end up in those courts, that you still get the services that you need, right? Nobody's getting out of Rikers better than when they went in. And I think we know that protocol, and we know that that is a true statement. So the first thing we do is identify the cases for mental health issues, beginning at intake. Our ADAs and our staffers have conversations with complainants who are, a lot of times family members. We have conversations with the complainants, with the victims, and of course with the officers and what they saw coming on to the scene, or whether they know a history of that particular defendant. The second thing we do is case evaluation. That includes reviewing the body cam footage. We determine, physical, whether they're under the influence, whether disorganized speech, fixation on government type of issues like conspiracies. And we also review environmental factors, evidence of hoarding, of disorganized homes, of the family members' behavior when they show up, things of that nature. And the third thing I think we look at is additionally, we look for signs during the court appearances. The ADAs ask, the counselor can ask for a 7:30 examination to make sure the person is competent. And I think all those things are the protocol that we initially follow, but we really don't stop there. ADAs flag cases after investigation and review, including speaking to the defendants. And it's important for us to know how someone enters the criminal justice system. Many cases that meet some of the protocols are referred to my diversion and alternative sentencing unit, which is part of our new rehabilitation program and restorative services bureau, which I created when I got here. It took me a few months to create it because I wanted to make sure that it was done right. We all know that failures in a new program lead to setting it back a very long time. We created that bureau. We have also the Crime Victims Advocate Program because we're here to serve and listen to the victims as well and consider the resources for the defendant and the victim because both of which probably deserve resources or need resources at that point. Our diversion and alternative sentencing unit is staffed by attorneys and clinicians, by the way, master's level social workers who can assess the defendants. And we work with a lot of our community-based organizations to assess our defendants for health disorders and all that comes with that. And I'll give you an example. We have our Veterans Court can help the defendant participate in a program for PTSD, and our CVAP can assist the family with resources. So a lot of this is looking at defendants as individuals, looking at cases individuals, making sure that we holistically see what is going on in that person's life before they end up in our courtroom, because everyone has their own history and everything that they have experienced brings them to our door. It's not usually that when they wake up one morning and they end up at our door. There's usually a buildup to it. Since January 2021, Mental Health Task has screened 87 SMI individuals for program considerations. And of those 87, 33% were actually incarcerated. So, there's a lot that we've done. I would say there are challenges. Placement for people with violent crimes can be difficult depending on the level of care that they require. We have few inpatient options. Keeping someone on Rikers until placement is a problem. And then you release them to shelters with an outpatient plan is also not ideal. And unfortunately, sometimes we are left with the best of two choices.
Thank you for that. A very thorough response. I just want to go back a couple of things you said. Could you just explain for people who don't know about TASK, what is that and how do they work with your office?
They work with our office and they come in and they screen our defendants. And then they evaluate as well. And it's only been since January 2021 that we've put it in place. We identify, the defense identifies, and then 33% of those that we've identified were incarcerated. The others we have recommended for treatment, and we can follow up on those numbers as well in the future.
So basically TASK is a nonprofit service provider that looks at these cases. So they're not a government agency.
They're not a government agency. They are a not-for-profit that we chose to work with and that we work with all the time.
Okay.
And we do that because of the importance of identifying them. I mean, I would like to think that my ADAs have that expertise, even if we train them, but unfortunately, it's not always the case. So we need to work with many of the outside agencies.
Mm-hmm. And at least you have clinicians in your office too, which is not always the case. So
we have clinicians in our office. We hire them for their expertise, and also we have the crime victims, which help also the defendants. A lot of the defendants that come in with mental health issues, their families are sometimes at wit's ends. Sometimes they don't know what to do, and they don't know a right path to move forward with the defendant, and they want to help. And so actually getting them involved in our system and not incarcerating their family member is sometimes a good thing for the family as well.
Right. Okay, so I want to ask about past practice in your office under the previous DA, and not to lay blame or rehash, but I want the listeners to understand how critical a role the DA is, that they really are the gatekeeper, and their policies can make a tremendous difference in whether people get diverted or not. So, again, during your campaign, you talked about the past practice in the DA's office. And I'm going to explain it, and then I'm going to ask you to put it in layman's terms. But the past practice required defendants to waive their what's called 180/80 rights in order to initiate plea bargains, and further that the plea bargains were not considered on anything less than what's called the top count after an indictment. So these practices made it difficult to divert people. So again, a lot of legal gibberish for non-lawyers to have to sift through, but can you explain that past practice and why, at least according to my colleagues who worked in Queens, this was really an obstacle to diversion?
Yeah, I thought it was a terrible practice. I was a very large advocate of the discovery practice because I thought that having the case known early on and having defendants know all of the evidence that the district attorney had early on was only helpful to everyone involved in the criminal justice system. So when I came here for years, the practice in Queens County was that if you did not waive your 180/80 right for your client, you never got anything but a top count plea. So in other words, defendants would get arrested, they come to the arraignment, they waive their 18080 right, which means they were never really arraigned on an indictment. And so that means that they literally could stay in jail for a very long time without actually ever having a judge hear the case, without an indictment, without all of the civil practices and civil rights that one is entitled to. So you could be in jail after a waiver for a year and more, quite honestly, in some of the cases. And since you waived your 18080 right, everything was still within the law. And then what would ultimately happen at times is you'd be there a year or two. Then the DA's office could come to you with a plea and say, well, you've already done time served on this, just take the plea. And then, of course, at that point, you just want to get out of jail and willing to take it. I will say the culture of evaluating cases early on is really the best practice. You got to do it early on. That's the reason that a grand jury was put into law. It's the reason that you're able to go to an indictment arraignment. It's the reason that we've changed the discovery laws so that everyone involved in the individual case that you're talking about knows what's going on. And as I said during the campaign as well, I believe I'm a very good lawyer. If I can't prosecute a case with the defense counsel knowing everything I know, then I probably should not be prosecuting that case. And so, you know, you still can waive the grand jury under certain circumstances and when it is really best for the client, but it's not an automatic anymore. And by the way, even if you waive it, you still have a right to a something lower than a top count plea.
Great, thank you. Thanks for that explanation, appreciate it. So we really do need to talk about Rikers, unfortunately. You know, we've been doing these conversations. I think the first one was October, or actually in September. And I keep thinking that we won't have to talk about Rikers or we'll have some better news, but it seems like the news gets worse. So we need to talk about Anthony Scott. He became the 14th person recently to die in New York City jails this year. Mr. Scott was autistic and he struck a nurse during a mental health crisis. District Attorney Vance's office decided to prosecute the case and bail was set at $15,000, clearly more than he could pay. Shortly after being held on Rikers, Mr. Scott died by suicide. So the Vera Institute of Justice and Color of Change have organized a letter urging DAs to release more people from Rikers. And in full disclosure, the Greenburger Center has signed on to that letter. So specifically, the letter from Vera and Color of Change calls on DAs to adopt 3 basic policies. And they are: first, release everyone in jail facing low-level and nonviolent charges. 2, rely on the city's extensive network of community-based service providers and alternative to incarceration programs to individually review cases, and then to consider release for everyone else. And then 3rd, to stop requesting bail amounts that are well beyond what New Yorkers can afford. So will you commit to adopting these minimum policies, especially as they apply to those living with mental illness?
So I want to start with a few facts, if I can, for Queens County, because I think we are a little bit of an unusual county. So I just want everyone to know what it is. First of all, out of, I think, the 6,000 people at Rikers right now, if I'm not mistaken, I don't know today's numbers, 520 are from Queens in all. 441 of those have been arrested for violent crimes. So 265 are there on bail, 16 are there on dollar bails, which means that they were on parole and got rearrested. Usually it's rearrest, violations of an order of contempt because of, usually it's DV. I'm not saying it's all DV, but normally it is. And 157 people are remanded. Those are the securing orders for violent defendants at Rikers. Non-violent, 34 are there because of jail in lieu of bail. Normally that would mean, in our world, a violation of an order of contempt, recidivist to the point where, you know, we had one guy who was arrested, I think it was on the front page of the paper, like 46 times, and then got arrested for a violent crime. And, you know, it's so those, I'm just letting you know that those are our numbers. 21 of those non-violent are there on dollar bails as well, which means they got rearrested after they were out on a misdemeanor or felony. 19 of those are remand. For non-violent felonies, we have 15 people there. So our numbers are relatively small compared to the rest of the city. And that is, there's a lot of reasons for that. Number one, I have lowered the major ask, the top count ask for bail in my office. If we believe someone should be remanded, we ask for it. But we're not asking for something like $300,000 in bail because it's the same thing as remand, because it is not. If you are dangerous and you can afford $1 billion in bail, you should probably be held the same way someone who can't afford $1 should be held. So I have put a realistic look on those bail asks. So the question really becomes for Rikers. What do we need to do for Rikers and mental health services? Number one, it would be very helpful if we had a better system to send people to mental health services during a securing order. So in other words, you get arrested, you're in court on within 24 hours on the arraignment of that arrest. For a securing order, we're very limited on what we can do. So because the law in New York State allows you only to hold someone in bail if you don't think they're going to return, I don't think there's a realistic assessment of the individual and programs to send them to in lieu of asking for bail in New York, or at least in Queens County. I am trying to implement that. We are working on implementing that. We need to get the program correct because you don't want it to go wrong. And so we are still in the process of that. But Rikers Island is certainly not conducive to mental health treatment. It wasn't built with the current mental health standards in mind. It's a penal institution. And it really is not the right place to accommodate therapeutic treatment. Therapeutic environments are created for particularized populations. Lighting, air, circulation, nature, spaces to facilitate individual group work are top of the list of things that you need. Additionally, people with behavioral health disorders or any medical need, they require continuum of care, and can't be disrupted. And we see this approach with assertive community treatment teams, the treatment professionals that are meeting with individuals. And so, look, I understand the concern. I believe in the concern and agree with the concern. I think we need to start with a better system. In my office, we are trying to get there every single day. It is the reason our numbers are so low.
Got it. Thank you. So I do want to ask you a little bit about the treatment or lack of treatment at Rikers, but just to follow up on your response, other DAs have said time and again that they are missing that kind of in-between treatment option for
Yep.
people who, you can't really let out pre-trial. You don't want to keep them at Rikers because it's, as you just said, it's not a place for treatment. It's not therapeutic at all. But they have perhaps a higher level of mental illness and a higher level felony charge, and there's just no option for them. Of course, we're trying to put an option like that together, but of the people that are in, do you have a sense about how many people fall into that category of where they need help, but there's nothing out there for them?
So no, and I think that's one of the problems that we have, which is that a defendant comes in, the counsel asks for 730. They go, they get assessed, they are treated, they have the drugs that maybe they haven't been taking, the medicines that they haven't been taking. They are deemed to be able to help in their own defense. Then they end up at arraignment, and then they go to Rikers. There's not an in-between. And I'm going to say a little commercial for things that I have been fighting for, which is this. I believe that cash bail is not a good way of doing business. I believe that we can't just look to see whether or not a defendant will show back up at court as to whether or not there is bail. I think we need a discussion about the entire defendant. I know that we don't want to talk about community safety here in New York State. 49 other jurisdictions, 49 other states, just to keep that clear, have danger to the community or community safety in mind when they're talking about it. I think if we got to no cash bail and we had that discussion, there would be a lot more room to be able to talk about using mental health providers as securing orders before they even get to trial, to be able to get treatment, even if it's out treatment, right? Someone shows up for mental health illness services twice a week while they're waiting for their trial, and then they can be at home with the family and friends and people that love them and their support system. And I think that's a real concern of mine, is that we can't, and by the way, it's not only with mental health. I know that's what this is about. It's also with younger individuals who are not really in a gang yet, who need mentors and people to show them the right path and the right trail. The capacity for a securing order before a trial to send people to programs like that is extremely limited in the way New York law works. And I think we'd be helping an enormous amount of people to be able to get them the help that they need while they're waiting for a trial. Or, by the way, figure out a process in which they're waiting for a trial, like we do some diversion programs that are not really that violent. You know, some violent programs too, if to say, well, if you go to the mental health treatment, if you go to the cure violence groups, if you go to mentorship programs, if you actually participate, you know, then we talk about what is left on your record, because maybe then it's less. I think it's extremely important.
So for those who do have to go to Rikers, though, you, again, as a candidate, you were a strong advocate for mental health services in the prisons. And you said that too many people are released from jail without adequate care to respond to their mental health needs, and treatment needs to be a systematic and coordinated plan to assure the best for the individual upon release. So what have you been able to do to change the health services at Rikers, if anything?
So we work with Rikers quite a bit. Unfortunately, we were not able to do as much inside as we would like to do. Remember, we don't have as many people there in order to get the treatment. What we do is a reentry program into the society, and we work with individuals as they come out as well, and with a lot of the organizations that are on the ground that have a system in place in order to work with them. We work with the Fortune Society in order to make sure that people have some sort of a safety net as they come out, especially with diversion programs. But the truth is, the answer really is to never get them to Rikers. And in order to create those diversion programs where appropriate, where they're getting the treatment instead of going right into Rikers. So my perfect world is that we see someone has this history. We see that from the body cams that there are clearly mental health issues at stake, and we figure out some sort of securing order that allows for the mental health treatment to be able to either go on site or to be able to get the treatment as they go on and be with their families. And then they show back up in court and deal with the charges. And then we figure out whether or not those charges still stand as they are. I think that's the better way. And we are trying to get there. It is not an easy task to get there when the system is built around certain types of policies.
Got it.
And if I can add to that, I've done what I can on the inside of my office. And now we are continuing to try and bring those policies to the rest of the agencies.
Okay, so I want to talk about policies at NYPD, and I wanted to focus on the Peggy Herrera case to have this conversation. So Peggy Herrera, like so many of the moms that call me, is a mom of a son who has mental illness. And when someone has mental illness, a loved one, and they go into crisis, there's always that question, well, who do we call? 911 or someone else. And in August 2019, Peggy called 911 to seek help for her son, Justin, who was experiencing a mental health crisis. By the time the police arrived, Justin was calm, and Herrera asked police not to enter her home and tried to block their entrance. She was concerned that it would escalate, as unfortunately so many times it does. But NYPD policy mandated that they enter the home. When Herrera tried to stop the police, she was arrested and charged with obstruction of governmental administration. You eventually dropped the charges in the quote interest of justice. So tell us a little bit about that case and what impact, if any, can a DA have on NYPD's policies around people in mental health crisis and their loved ones?
Look, I think it's a hard position for the police to be in. They get a 911 call. I do have a history of dealing on a personal level with people that have some mental health illness. And I think it's hard on the police as well. They show up, they were told that someone's trying to commit suicide. The mother's standing outside. As we know, people want to protect their loved ones as well. And they have to make a real-time decision as to what to do. If they walk away, the mother's locked out of the house, remember, at that point. And I have to admit, I wasn't around at that time. So I was briefed on the case. Usually in a case like this, I might show up to the scene. Many people here know that I show up to a lot of the crime scenes just to see for myself. But I didn't. I wasn't around. The police show up. A mother's locked out. The son's inside. The mom is saying he's fine. They got a call that says he's going to kill himself. I mean, I guess they can walk away, but then they are risking walking away, him killing himself, and then the situation would be a very different situation. I think at this point, arresting her, I thought was not the right thing to do. I understand the protectiveness of your family members, the protectiveness of someone saying, I know him, he's okay now. And I can absolutely see that happening. But I think the situation, I can't second guess what happened there, except to say that the need to arrest the mother, I thought was not in the interest of justice. I do think we need better training. We also need to do a lot more than better training, right? We need to utilize some sort of programs. I know there's programs in other states like Oregon. I think you have the Cahoots program, where there's training for officers, training specific officers that have mental health training. And I think that's important just besides ESU. I know some of the cops also have that training, but I think it'd be great to have some sort of program like that in New York. I think that people calling the police have to clearly identify that there's a mental health crisis going on or a medical crisis as well. But a lot of cops show up and don't know that, and they have to make real-time decisions. I also think that there is value to having a number someone can call when they know that it's a specific mental health issue. I know there was some talk of a 988 number where people can call and say, look, it's not really a police emergency, but I need help with my family member or a friend who's going through a crisis right now. So I can't have you walking in here with guns blazing. I can't have you walking in here. Now, the protocol for police, just so you know, from my understanding, is they are supposed to secure the person in a place where they can't do damage to anyone, and then wait for ESU to come and try to talk people down. My understanding in the Peggy Herrera case, and again, I wasn't here at the time, but I did get briefed, is that ESU was on site and they were trying that, and it wasn't working. The only judgment call I made on that day was that the arrest of the mother, I thought, was a little over the top. I did not think it was the interest of justice to punish someone trying to protect their child, and I dropped the charges.
Yeah, fair enough. Yeah, as we've heard from other DAs as well, they and the police are put in an unenviable position, to put it mildly, when mental health system fails, and this population falls through the cracks and ends up on your lap and the police lap, and it's to say it's not fair is an understatement. It's worse than that. It's ineffective and expensive and cost people lives. So I appreciate the conversation and about bringing both sides to light.
Yeah, and by the way, I mean, those that have dealt, and I know many people on this Zoom have dealt with people with mental health illness quite a bit. I mean, in the heat of that moment, nobody knows the individual except for the family member. And and we all know that there are, at least in many cases, I'm not saying all cases, there are certain triggers. Police showing up at the scene don't know the triggers, right? And they don't know exactly how people are going to react. By the way, like a defendant, but it's different because someone is experiencing an episode normally when they're called. And to try and pull someone out of that episode, sometimes you do need to rely on the family members to say he's fine now. And I think family members are also really worried about calling help because they always think they can talk their family down. And by the time they call the police department, I think it's important to note for law enforcement that they're at their wit's end, right? It's usually not the first go-to, right? It's usually the last go-to. And so I think that there's that understanding that has to come to the scene of the incident.
Yeah. Okay, so let's talk about mental health and drug courts in terms of unintended adverse outcomes that can sometimes happen. We've heard it certainly in other jurisdictions that people who enter particularly drug courts, there is some reluctance by the defendants and their counsel to enter a drug court because if they slip up once or twice, if they relapse, which is really, we understand now, part of the disease, they can be subject to, at times, worse outcomes than had they just pled up front and not gone to drug court, which really defeats the purpose. So are you experiencing this? Is there something that in drug or mental health court, and is there something that your office can do to give the second chance that might be needed and to make the process more fair?
Well, I think there's clearly a tension, right, between someone has a behavioral health disorder or a serious mental illness, and there's a nexus, right, between their disorder and the crime. And we certainly don't want to punish people for their mental health illness. And the tension arises because their behavior is causing harm to others, right? We make offers that are fair. We take them into account. I know that you, I think, have met Aisha Green, who has come on as head of the rehabilitation and rehabilitation unit. And we have tried under my administration to build in mistakes. We have tried under my administration to build in the fact that nobody's perfect. And I think that we're learning that in the parole laws too right now, right? Less is more. We're learning people make mistakes. Things happen. People are late. They're hanging around with someone maybe they didn't know had a record, right? So we're trying to build in those types of mistakes to the drug court as well. And I think that we've been quite successful in doing it. We take into account that people do have setbacks. And let's face it, when you're dealing with mental health, it's a lot of time, you experiment with different types of treatments, different type of medicine, and you try to get that spot where someone can go on and get a job and work hard and really succeed in life with their family and their work and with themselves, to be honest about it. So we do take that into account. Aisha has been great in making sure that that happens as we move on. And nothing's going to be perfect, but we do our best. I can't hear you. I'm sorry. I can't hear you.
That's because I was muted.
Oh, okay.
Thank you. I was just saying, I was singing Aisha's praises and saying that's a great resource for you to have in your office. So I'm going to go to some audience questions now. So I apologize for looking down, but I'm getting questions sent to me on the phone. And also there's some questions in the chat. I see that Peggy Herrera is on the Zoom, and DA, she's thanking, I don't know if you can see that, but she's thanking you and says it's the first time she's heard your heart straight from you on my situation with my son. So.
Thank you, Ms. Herrera. I think that it was important. Everybody understands trying to protect your child. Yeah.
Okay. So the first question is, can you elaborate on the 87 freed with SMI? I apologize. I don't know what this question is referring to. And you're muted.
I'm sorry. Okay. So our courts screened the 87 people and 33% were incarcerated But the others, those eligible for programs, they proceed into our mental health court. And so we work to make sure that they get the treatment that they need. Usually at the end of that, it's either a lower plea, but mostly it's an ACD, which means acquitted in contemplation of a dismissal. And so we try our best to get them into the court. In mental health court, quite honestly, we have it down a little better for misdemeanors than we do for felonies. And so we try to make sure that they get treatments on there.
Okay, this question says, what is your office's position on no plea diversion? Why do mentally ill clients have to enter a guilty plea in order to access ATI programs? Many of our mentally ill clients commit offenses while off their medications and don't have the mens rea when offense is committed.
So in a misdemeanor, most of the time we do not require, or actually we're working towards not requiring a plea of guilty. I also would like to work more towards that in the drug courts as well. And I think that we've had a better chance and better luck doing it there. We are working towards doing no plea of guilt in the diversion for misdemeanor. I will say that for felonies, it's a little more difficult. There's usually a history. There's usually individualized problems that we are dealing with. They're normally more top count pleas. They're normally a little more violent. And until we get the resources available for those violent felony crimes, it's a little harder to do that. On the misdemeanors, I actually believe we're going to get to no plea, getting to a place where they don't have to enter a plea in order to get the services. That's where I am gearing towards. I wish I could do it a little faster, but we are making headway in that.
Do you have other jurisdictions who are doing that?
I think there are some. I think the crimes are a little different and the setup is already there by the time they got there. I know that Staten Island does Project Hope. I'm not sure exactly where their plea falls in place. I do know that our courts were a little bit different when I got here. I think it's important for everyone to remember that in 2 years, I think we have made enormous headway in this office in so many different ways, including the diversion courts. But it is my hope, and it is Aisha and everyone on my staff's charge right now to get to no plea for diversion courts, especially for misdemeanors for drugs, for mental health, for drugs for mental health, and for veterans court. I think we're much closer in veterans court than we are in the other courts, but we are working towards making that the norm.
And in veterans court, so the experience so far has been good?
Yeah, in veterans courts, it's good. I think that it's a little bit more difficult on PTSD to figure out exactly, to judge and to have opinions on why the crimes happen. I think most of the crimes that happen for veterans court is clear that it's because of PTSD. It mimics some of the mental health issues, and we are able to give many of them a break, or at least treatment, not really a break, but treatment to make them better than they were when they came into our system.
Got it. Okay, another question from the audience. What is your position on offenses committed while our mentally ill clients are in a hospital setting or OMH facility such as Creedmoor, while in a compromised mental condition? Why are these cases getting prosecuted?
I don't know. I have to tell you, I don't recall people coming across my desk. It may be that it's coming to the office where a crime is committed in a hospital while they're undergoing treatment. That has not come across my desk personally. I'd be happy to look into that and get back to the Institute so that you can make sure that people know the answer to that.
Okay.
I would say though that, I mean, if they're in for mental health illness, the idea of prosecuting them on a crime that's happening while they're getting treated, I would assume it's unusual, but I'd have to ask my office.
Right. I would assume that this question might be kind of harkening back to Anthony Scott, who, was, I guess, in a hospital getting treatment and struck a nurse and then was prosecuted for that. So, okay. Another question. What is the role of public defenders in addressing these issues?
Speak up for the clients. I think the public defenders are amazing in speaking up for their clients' needs. I think that at the end of the day, I meet with the defenders, I don't know, probably once every 2 months. We have a call with the leadership of 18B, of Legal Aid, of Queens Defenders, of the private bar, and we talk about all of these issues. I think speaking up for the defendants is what they do, and they do it great. I think that we need more than 730. I think the fact that we have the 730 defense, and we put them into an assessment, and then all of a sudden they're okay for standing trial and answering for their crimes. I think we need more than that. And I think that together we could probably get more than that. I think that I would love it if defense attorneys worked with us in making sure that we get securing orders that were other than just bail, CJA, which is supervised release, remand, or ROR. I think there are so many other ways to have securing orders so that people are actually getting help while they're waiting for their trial. And to work as a team for that is extremely helpful. I do think there are discovery concerns, and I understand those discovery concerns for all of the defense attorneys that are on this Zoom. And I think we are trying to work that out as well. And then the question becomes whether you need discovery if you're going to go into a treatment court, not-for-profit. And I do understand those concerns, and we'd be happy to talk about those as well. But I think all of us speaking in the same voice, saying there has to be a middle ground. There's got to be a way between being fit for trial and being judged to not be responsible for the crime you committed. There has to be a middle ground. And I think that I am constantly a little frustrated by the fact that there isn't.
Yes, you and us and lots of people on this call as well. I'm going to ask a longer question, but a quick just statement. Someone is saying who works with the population that PTSD is a DSM mental health diagnosis. It comes across as if PTSD is being separated from mental illness, but it is a mental illness. Just to clarify for people. Okay.
Yes, but sometimes harder. Yeah, I agree it is a mental health illness, and that's what I meant. I think though, we have to decide that if someone comes in who's a veteran who commits a crime, whether because of all of the analysis and all of the assessments, we believe it's because of the PTSD, and whether there are those issues of mental health illness. And I think that's a little harder sometimes to evaluate, although we've been quite successful in working with the veterans courts. But that's really all I meant. I think that that's exactly right. I just think the judgment of it is a little bit different.
Okay, so this comes from Jeffrey Berman, who is a public defender in Manhattan. And he says, research has shown that people with mental disabilities are more feared, more stigmatized, discriminated against more often, and are seen as more likely to commit acts of violence than are people with physical disabilities. However, people who live with a mental health disorder are 10 times more likely to be victims rather than perpetrators of violence. Critically, people accused of violent offenders are not only the most, critically, people accused of violent, I think he means offenses, are not only the most in need of court-mandated treatment, but excluding them makes no sense. Studies show that there is no added public safety risk of jail diversion in general, and people charged with violent offenses will do just as well in treatment as those charged with non-violent offenses. Do you agree with this statement? What percentage of people charged with violent offenses are allowed into the Queens Mental Health Court? And there's a lot of questions here. I'm just going to say one more. And are you committed to significantly increasing participation for people charged with violent matters?
I'm not quite sure I understand the exact question. I can only say that it sounds like it's the reason we need more mental health service organizations involved with the court system from an earlier perspective. And I think that's really the biggest frustration that I face. I spent 2 years working on making sure that our diversion programs and the not-for-profits we work with are stellar. Part of the reason I'm doing that is not because I don't think people deserve the diversion, because I think they do quite often, but I also want to gain the credibility for our court system to feel comfortable using those same organizations for securing orders. So you get arrested and, some not-for-profits gain the confidence of the bench and, by the way, of my office and the community to be able to use those not-for-profits as securing orders as well. Something that is very difficult to do in New York, since the only obligation at an arraignment, quote unquote, is to make sure that they show back up at court, not the state's responsibility to make sure that they show up better, not the state's responsibility. And it should be, we should be making sure that we have eyes and ears on a defendant. And if we can get them treatment and make them better before they come back to court, isn't that a win-win for every single person involved? But I would say that, and maybe this is great for like the last closing, this is why we need organizations and institutions like the Greenburger Institute and the plan that the Greenburger Institute has for creating that middle ground. And, it is a very hefty responsibility and a very hefty job that you are trying to do. I would argue that if we can't start from the beginning and take care of the little things, like securing orders, like the diversion courts being better, which we are every single day making them better. They're not perfect yet, but we're making them better. Then it's going to be difficult to get that really hefty responsibility of a Greenburger Institute. But I have to tell you, you are amazing in getting there and opening up this really needed conversation for everyone involved.
Well, I can't thank you enough for your comments and support. I think sometimes feel like, we're very frustrated. I would just say after almost 7 years and we don't have a facility open yet, but we hope to break ground in the spring. And it shouldn't be this hard. As you've been saying, it shouldn't be this hard, but it is. And it really has to do with money. It has to do with how these facilities are funded. Because as I've said before in other programs, we know how to treat this population. If you're wealthy, you'll go to someplace like Silver Hill. If you're poor, you'll go to someplace like jail or prison. And we know that we can treat you in a Silver Hill. So it's really about funding streams and unlocking those funding streams. And that's what we've been trying to do. And we hope to have more, some good news for you. And we'd be happy to take people from Queens.
I think also, though, we need to, I think vocalizing and internalizing the idea that it's not all one side and that there has to be this discussion of both issues, right? We need to make sure that we are treating mental health illness and all that goes with it, because it's better for the defendant. But quite honestly, it's better for society as well, right? Because if you're going to go into Rikers or state prison, you're not coming out better. You're not coming out cured.
Yeah.
And I think that is a balance, though, between keeping communities safe as well. And I think we need to balance both. I think one of the problems in today's society is everyone's on one side or the other. And I say this in many of my speeches, even when it's not politically correct at the moment I'm saying it, but I'm going to say it. There's not one side or the other. It's not always this way or always that way. Part of my job as a district attorney is to have a steady hand when people are asking you to take sides one way or the other. I think the reason that we have been relatively successful in our diversion and relatively successful with our mental health illness issues, and the reason that Aisha, who is head of the program, is given so much freedom, is because I do try to bring that steady hand between community safety, mental health illness, the securing orders that I find very frustrating. And so we need to really look at it from a holistic approach. And I think Greenburger is trying to do that. And I thank you for that.
Thank you. Thank you. Appreciate it. So we only have 3 minutes. So one quick last question from our audience. Are there any state law changes that you think should be made to help your office better address people with mental illness?
Yeah, I think we have to have a realistic conversation in court about the actual defendant that's in front of the judge. I think that there needs to be a way for us to have a better assessment when they first enter the criminal justice system than we have right now. I think that the bench does the best they possibly can I think they are amazing individuals who really want to do the right thing. The problem we have is that when someone is arraigned, the only thing I am allowed to look at is whether or not they're going to end up back in court on their trial date or on their next return date. And I think that that is I don't know what the word is, but that's not a real assessment as to who the defendant is. I think that that's an important part of this. I know that we have assessments. CJA comes in, they assess them whether or not they need a 730. So I have tried to replace my office with what I think the criminal justice system should do. We have tried to assess at every single level that the defendant is in our purview. We look at it in arraignment. We look at the body cam. We look at intake. We try and figure out whether or not along the way, I call it stopping the train, which means that, when I hire new ADAs, I tell them, I need people who can think out the box, and I need people who are willing to stand up to other ADAs and to the police department when a train is moving, when a case is moving, to be able to stop it and say, hey, let's take a look at whether or not X is true. Let's take a look at whether there was mental health. Let's take a look at other ways to look at this. And I think it's extremely important. I formed the Bureau to be able to look at these issues, and we are making great headway in it.
Well, thank you so much, DA. It's been a pleasure to speak with you and to hear about the changes in your office and how you're moving forward in the short time that you've been in office to date. So look forward to hearing more about your programs in the coming years. And thank you all for joining us and for your great questions in the chat. Appreciate it very much. And we'll see you on November 10th with DA Vance.
Thank you very much. We appreciate both Greenburger and John Jay.
Thank you so much.
Bye-bye.
Have a good morning.